post. This is the record review to consider the appointment of a Board of Managers for the Beaumont Independent School District as detailed in the Commissioner's letter dated April 14, 2014. The agency has previously provided a record review to consider the lowering of the district's accreditation status and the appointment of a conservator. Those actions were sustained in a decision issued on June 16, 2014. That prior record and the decision will be made a part of this record. All information provided today will supplement that record. I will consider all the relevant information in the record when making my decision. This is a meeting and it's not a trial, and I'm not a lawyer. The rules of civil procedure and evidence do not apply. The agency and the district will have an opportunity to present their positions. I ask that you please do not interrupt each other's presentations by making objections as if this were a trial. If you think the other side has put information into the record that is irrelevant, immaterial, or unduly repetitious, please tell me that when it's your turn to present, and I will take these arguments into account when I make my decision. You may present information in question and answer format, but you are not required to do so. Please speak into the microphone to ensure that your presentations are recorded. The record review is scheduled for an hour. I understand the district doesn't think that an hour will be enough time. If necessary, I will allow the district an additional 15 minutes at the end to complete the presentation. Please manage your time appropriately. Both sides may make a brief opening statement, and then both sides will have an opportunity to present reasons why I should or should not take the proposed action. After each presentation, you will have the opportunity to ask questions of the person presenting the information. Both sides will have an opportunity to make a brief closing statement, and after that, I will close the record and issue a decision as soon as possible. I will now turn this over to Mr. Jones.
Can I ask one question?
Yes. Yes.
Does the closing statement go into the time part, or is that exclusive?
That was going to be in the time part. What I was planning to do is when we hit an hour, just to let you know that you're in an hour, and if you still wanted more time, then just to say we're adding 15 minutes, and yes, that would be included. Yes. Yes.
How would you like to be referred?
Well, normally, I guess if we weren't in a hearing, you could call me anything, but probably for the sake of the hearing, just call me that Mr. Berry is fine, or Commissioner Berry. Either one is fine.
Okay.
So thank you very much for asking. All right, Chris, if you'd like to get started for the agency.
All right. Good afternoon. Today we're here for the record review for the appointment of the Board of Managers for the Beaumont Independent School District, and we will show that the problems that we previously identified in the record review demonstrate that the Beaumont Independent School District's current state of crisis is the result of governance failures, and that a Board of Managers is necessary to correct these problems because the current board is either unwilling or unable to manage the district's operations in a manner that would prevent significant operational problems from occurring, or to detect problems that have occurred under its watch, or to solve the problems that other entities have identified for the board, and this action is therefore necessary to protect the welfare of the Beaumont Independent School District students and to protect the public interest. We are here for a second part of this record review after the district's attempts to enjoin the process by seeking the intervention of the Travis County District Court have failed. In that action, Judge Alanowski declined to enter a temporary injunction because he ruled that the district was unlikely to succeed at trial in convincing the court of their interpretation of the law. He ruled that the commissioner did have the authority to conduct the special accreditation investigations that are the subject of this action, that the commissioner has the authority to appoint the Board of Managers based on the findings of the special accreditation investigations, and that even if the statute does require that the school's accreditation status be lowered prior to the installation of the Board of Managers, that the commissioner has the authority to lower that accreditation status, the current one, without waiting for the next one to be issued. And then finally, that the board as a whole and that its individual members have no legal entitlement to uninterrupted authority that would require a due process hearing before the board is temporarily suspended in favor of the Board of Managers. Thank you.
Thank you, Mr. Berry. Thank you, Mr. Berry, and thank you for hearing from us. My name is Chris Tritico, representing the Beaumont Independent School District. With me today, who you didn't meet, is Ms. Gwen Ambrose, the board president, and Dr. Timothy Shagwell, the superintendent of schools at the Beaumont Independent School District. What we will show today is that the commissioner has overstepped his authority in ordering a board of managers, that the action that he seeks you to confirm today is in direct violation of the Texas Constitution and the way that elected officials are removed. In addition, that and I hate to use this phrase, but the punishment doesn't fit the crime. There are other districts in Texas who have had far worse problems than the Beaumont Independent School District that did not end up with a board of managers. Specifically, and we'll show, and it's already in evidence, actually you've already got it, that the Dallas Independent School District, who suffered a far greater, Plano Independent School District, who suffered a far greater theft of funds, where a board member was actually indicted along with the person who was stealing the money. They didn't get a board of managers, they got an academic conservator to oversee the district's academic problems, and the financial problems, I guess, were not dealt with. And so what the commissioner is doing is in violation of the Texas Constitution, and he's stepping up a process that can be dealt with less restrictive means. Thank you. In addition, for your convenience, we transcribed the last record review. And that'll just, in case you want to refer to it when you're making your decision, there it is, and that should help.
Thank you.
All right, I would like to proceed with Dr. Lisa Dawn Fisher. Dr. Dawn Fisher, in front of you is a set of 3 rules. It should be Rule 97.1057, 1059, and 1073. I've provided copies of these rules to the parties and Mr. Berry. And if you could start by referring to Rule 97.1057, and I'd direct you to subsection E, where the best interest of the students are defined.
Yes.
And 97.1057E1 states that ineffective or inefficient use of the district's funds is contrary to the best interest of the students. Can you explain how the findings in the 2 investigative reports that we discussed at the last record review demonstrate that the district's use of its property was either inefficient or ineffective?
Well, we have actually conducted 2 investigations looking at the district's expenditures and financial management, and in both cases we found that the school district did not have good controls over its bond program with regard to payments to contractors for its facilities and construction, in particular electrician services. We found that they lacked internal controls that would help them identify potential fraud, waste, and abuse. We found that they had contracts that were being let to vendors that had conflicts of interest with either staff members or board members. We found that there was a number of different vendor lists, so that rather than having one single vendor list that was an approved vendor list for folks at the school district to order from, instead we found 5 different lists that had different vendors listed on them, some of them overlapping, some of them not. We found that the district had had lost the security or lost control of the pass key that allowed wire transfers to take place, resulting in embezzlement of $4 million by 2 of its former employees. The list goes on, but that's a pretty fair example of some of the more egregious problems that we found in those investigations. Okay. And in addition, how was the district doing on its budget? We found well, that for one thing, we found that the district has been overspending its budget. It's been spending more money each year for the last several years than it brings in revenue. As a result, it's caused a depletion of its fund balance over the last few years, to the point where the district has had to declare financial exigency and is looking at a significant reduction in force in order to bring its budget in line with its revenues.
Okay. And I'm going to draw your attention to the next subsection, E2, that says that it's contrary to the best interest of the students for the district to, when it fails to account for its funds. Can you explain how the findings in your investigative reports demonstrate that the district has failed to account for its funds?
Well, we found a widespread lack of internal controls that provide the opportunity for the misuse of funds for fraud, waste, and abuse. And then certainly we saw that that has occurred with the indictment and charges against the 2 individuals who were embezzling funds from the school district. We found that it appears that they have allowed vendors to bill them inadequately. They've paid those bills. We found that that problem was occurring in 2011 when we did our first investigation. And 3 years later, when we went back, we found that that exact same practice was still occurring, that they had not corrected that problem, even though they had known about it for a number of years by that point in time. We also note that there was a legislative budget board report that identified thousands of amendments to budget that would be adopted at the beginning of the year, that they had what more or less a runaway budget because they just kept amending it until they were spending more money than they were bringing in revenue and having to dig into the fund balance to be able to pay their bills.
Okay. And how does this type of financial mismanagement affect the district's ability to produce audited financial statements?
It apparently affects it greatly because we still haven't received the audit for the 12-13 school year that was due at the end of January. Although the district apparently never lost control of the financial records that they would need in order to complete that audit, based on my conversations with the FBI recently.
Okay. And what is generally the happen when somebody gets indicted and the FBI takes records from a district?
I'm sorry, I know you asked us not to object, but this is complete speculation for someone who's not a lawyer and doesn't deal with criminal law, and I object to it.
I so noted, but I'd like you to hold your thought, and as soon as it's your time, I'd like you to address what you think is inappropriate. Keep going.
I had a conversation with the FBI agent who was involved with the seizure of records from the Beaumont Independent School District related to the embezzlement. He told me that the district never lost control of its financial accounting system during the entire process. They never seized the computers that had the financial accounting system. The only computers that were seized had the email servers on them.
And is that consistent with, if the district had lost control of all of its financial accounting software, would they be able to run their normal business, pay their vendors, their payroll, and things like that?
No, they would not be able to. And as far as I know, they never had a disruption in their business operations. And I confirmed with the FBI that they never lost the computers that had that information on them.
Okay. And then I would like to draw your attention to the next rule, which is 97.1059. And I'll direct you to subsection B, which states that when determining what sanction to issue, the commissioner shall consider the seriousness, number, extent, and duration of the deficiencies. So those 4 things. Can you first describe how your reports, if they tell us that the district's problems are serious?
Well, they're serious enough that they resulted in charges of embezzlement against two of their employees. They're serious enough that we know that they continue to have problems managing the vendor contracts, that we know they were not monitoring their cost-plus vendor contracts. We know that the school has problems with their special education program that have resulted in the special education students not receiving the appropriate services they were intended to receive and are entitled to receive by law. We know that the school district has declared financial exigency and is looking at laying off hundreds of employees because their budget is out of control.
Okay. And can the types of problems that the district is experiencing in its financial management affect its bond ratings and its borrowing costs?
It certainly can. Since the time of our release of our report and the release of the LBB report, the school district has experienced a downgrade in its bond ratings, and a downgrade in bond ratings can result in higher interest rate costs for the district in its future borrowing.
Okay. And on the next point, can you tell me whether these problems are numerous?
They're very numerous. We found several findings when we went out both times in 11 and 2013. The LBB had at least 85 recommendations surrounding improvements to the school district's operations in their report as well.
Okay. And how about in the special education area?
There were numerous findings in the special education area with regard to the lack of appropriate training for staff, the lack of appropriate documentation for special education students' services that were required, and what I understand from reading the reports on the special education program, the students were not having appropriate committee meetings to determine their individualized education plans, and so without the committee meetings and without the plans, the students were deprived of free and appropriate public education.
Okay. And can you tell me whether these problems are extensive?
They're very extensive. The lack of internal controls is pervasive throughout the operations. When we took a look at it, the lack of internal controls provides opportunities for folks that are inclined to fraud, waste, and abuse that can happen. Certainly saw evidence of that. It's particularly with the management of vendor contracts, or really the lack thereof, and the multiple vendor list. The extent to which employees in the district could make purchases that were inappropriate or in excess of the budget is widespread.
Okay. And can you tell me whether these problems have been long-standing?
We know problems with the procurement process and the vendor management have been going on since at least 2011, when we did our first investigation at the request of one of the board members to look into their bond program. And what we did see is that upon return, that virtually none of the problems that we identified in the original report had been corrected. We also noted that none of the recommendations of the LBB had been acted upon by the time we arrived at the school district months later. Okay.
And I'd like to then direct your attention to B1. It's 97.1059 B1. Regarding whether a board of managers is necessary to address the deficiencies that were identified in these investigative reports.
I believe that's true, because this board has not been either able or willing to make the corrections in terms of development of internal controls, to require its superintendent to develop internal controls, to, literally directly address the problems that were identified in the 2011 report, the LBB 2013 report, or the report that we issued subsequently in 2013. We saw that it wasn't until the letters going out related to the accreditation sanctions did the board actually begin to take action to begin to correct some of these problems that had been identified for years.
Okay. And then referring to 1059B2, can you address whether a board of managers is necessary to address the recurring deficiencies of the district?
Yes, because this same board has allowed these same deficiencies to continue to persist for several years in a row and has not taken action to correct those problems after 3 years at least.
Okay. And then I would like to then direct you to the next rule, which is 97.1073, which applies to the appointment of a monitor, conservator, or board of managers. And I'd like to direct your attention to subsection E4. And can you address whether a board of managers is necessary to prevent the substantial or imminent harm to the welfare of the students?
Yes, it's definitely important to intervene at this point, because we're looking at problems for the special education students in terms of being able to get the services that they are entitled to receive under both state and federal law. We also are concerned about the interest of the potential harm to the students based upon the manner in which the layoffs occur. If they lay off a lot of teachers in the wrong places, they could potentially impact the ability of impact student performance, because one of the things we did see in looking at this district is that they are overstaffed in some areas and some areas of their personnel, but they are significantly understaffed in the special education department. So the manner in which these the reduction in force takes place has the potential to have significant influence on the students and their ability to perform in the future.
Okay. And then finally, can you address whether a board of managers is necessary to prevent the substantial or imminent harm to the public interest?
Fundamentally, the responsibility of the board is a fiduciary responsibility to the taxpayers of their district and of the state of Texas. And when we have repeated evidence that they are not being good stewards of the taxpayers' money, then there's significant concern about imminent harm to the public interest.
Okay. And then overall, then you made the initial recommendation to appoint a board of managers. Do you still believe that a board of managers is necessary to correct the district's problems?
Absolutely.
Okay. That's all I have.
Ms. Dawn Fisher, my name's Chris Tridico. We've met a couple times before, right?
We have.
Mr. Berry, we addressed extensively some of these issues in the last record review. I am not going to reinvent the wheel. I just gave you the transcript. If I don't cross-examine her on these points, I'm not waiving them. They're in that transcript, and I rely on the prior transcript and the prior evidence on the cross-examination of her regarding those points.
Sounds good.
These three sections of the Texas Administrative Code, 97-1057, 1059, and 1073, these are written by whom?
These are rules that are written by the agency, the Texas Education Agency, and adopted into the code.
Okay. The Texas legislature didn't pass these rules.
The Texas legislature either granted permissive or required authority to the commissioner to adopt.
Sure. My question was, this is not a law that was passed by the Texas legislature. This is a rule adopted by written by the agency and adopted by the agency.
That's correct.
There's no oversight of these promulgated rules by the Texas legislature, is there?
There's oversight by any member of the Texas, any person who lives in Texas. It's a public process.
Does the Texas legislature have to approve these after you write them?
No.
All right. Now, you talked extensively about the inefficient use of money and the fact that you did an investigation in 2011.
Yes.
And that was solely over the bond money, is that right?
That was focused on the bond money, yes.
Or the bond issues, I guess is the better way to put it.
It was focused on the construction program and particular concerns about how vendors were being selected and paid.
So bond issues is a fair way to put it?
Yes, sir.
Okay. I wasn't trying to argue with you. I was just trying to streamline it a little bit. And that was the only thing that was investigated in 2011, correct?
That's my recollection.
Okay. So the notice they got in 2011 was bond-related issues.
I assume.
Well, you were involved, right?
I didn't conduct the investigation in 2011.
Have you read it in preparation for your testimony?
Not recently, but I have read it before.
In connection with this record review and the prior record review and your work in general with Beaumont, you've read that investigation?
I have.
All right. So you know that it dealt only with the bond-related issues, right?
That's what it was focused on.
Okay. So the other investigations, the Legislative Budget Board, and your investigation, those were completed in late 2013, right?
Not quite. The LBB report was completed in August of 2013. I believe ours was completed in December.
Okay. So the second half of 2013, the Legislative Budget Board issued its decision or its findings, and yours came out at the very end of 2013, right?
Right.
The Legislative Budget Board gave Beaumont a year to complete what they had suggested, the 85 points they suggested, right?
I believe there were recommendations. I don't know about a deadline.
Okay. You don't recall that they gave them, they said it should be done within a year?
I don't.
All right. The investigation that you completed, TEA, I mean, not you personally, TEA completed in December of 2013 gave them a year, correct?
The investigation that my office completed didn't provide a deadline. I believe that you're thinking about a different office.
At any rate, oh, the special ed investigation gave them a year to complete theirs.
That's my understanding.
Okay.
Yes, sir.
All right. At any rate, if the Legislative Budget Board gave them a year, they haven't had that year to finish, have they? As a matter of fact, the Legislative Budget Board said should be finished by January 2015, is my recollection, right?
That's your recollection.
Is that yours?
No.
Okay.
I
What-
told you I wasn't familiar with that part
All
of the
right.
recommendation.
All right. You would agree with me that they haven't had, if that's true, they haven't had that amount of time, right?
I would say that they were aware of the findings
My
of
question,
the
ma'am, is
LBD.
if that's true, they haven't had that amount of time, have they?
They've
Yes or
known
no?
since February.
Yes
and-
or no? Have they had that amount of time?
Since when?
If they were given till January of 2015 to complete what the Legislative Budget Board suggested, they have not had that amount of time, have they?
It has not been January
All right.
2015 yet.
And on the special education investigation, if they gave them a year, they haven't had that year, have they?
It has not been a year since
Right.
that investigation.
And on your
was completed.
investigation, they had exactly 3 months before the commissioner sent a letter out saying he was putting in a board of managers, didn't they?
That sounds about right.
Right. And so when you're talking about all of the notice they had, all of the notice that they had from these various investigations all came within the last year, except for your 2011 investigation, correct?
That's fair.
All right. Now, you said you talked to the FBI. After you got the information from the FBI, surely you called the Beaumont ISD to verify what the FBI told you about the servers, right?
No.
Oh, okay. You didn't call me to ask me, right?
No, sir.
You didn't call Dr. Shagwell to ask him.
I had no need to do that.
Didn't call Gwen Ambrose to ask her.
No reason.
Now, you talked about the fact that you're concerned if they do this riff wrong, that it would hurt the students, right?
I am.
You are aware the board didn't do the riff, right?
I'm aware that they were.
Yes or no? Are you
enjoying-
aware that the board didn't do the riff?
I'm aware that they were directed not to, yes, sir.
Who directed them not to?
But I'm aware that there were problems on the board agenda that night.
Who
and that they
directed them
didn't.
not to?
I'm aware that the district attorney's office wrote to them and told them they had problems with the agenda that night.
Okay, and so it's your understanding that the district attorney, Jefferson County District Attorney, directed them not to do the riff. Is that your understanding?
My understanding that he told them that there were problems with the board agenda that night, and that in the ultimate they never voted on that item.
So your understanding is they didn't vote at all?
Not on that item.
Huh?
No, not on that item.
Man,
is
but
my-
you know what happened was, and I'll just tell you because I was sitting there when it happened, is they did vote. And there was 1 vote for and 1 vote against and 5 abstentions. That's exactly what happened. 4 abstentions.
So they didn't vote for it.
That wasn't my question. My question was, did you know that they did not approve the riff?
I know that there has not been a RIF approved.
All right. And you are aware that in preparation for the RIF, they hired an independent consultant to look over the entire district to come up with the RIF that they would ultimately approve. Did you know that?
I'm aware that they have hired someone, I think WCL Enterprises. I'm not aware, I'm not knowledgeable whether they advised them on this, or are you talking about
You didn't check
someone
into
else?
that before you made that statement that you're concerned that they might do the RIF wrong and hurt the kids? Did you ever check into that?
I know that
Just
they
yes or
have
no?
this.
Just yes or no?
No, I don't know.
All right. Did you know that the independent consultant that they hired worked with Fred Schaefer, the conservator, to ensure that they were doing a RIF that was appropriate and met all of the needs that was necessary for the district? Were you aware of that, yes or no? Yes or no?
That's different from the knowledge I have.
Did you ever talk to Mr. Schaefer?
I have spoken to
Okay.
Mr. Schaefer.
Did you ask him that specifically before you made the statement that you just made?
I understand.
Did you ask him that specifically before you made the statement that you just made?
I can't respond to your question yes or no because that is not my, it's not making any sense.
It doesn't make any sense? My question doesn't make any sense?
It
Did you
doesn't.
ask Mr. Schaefer, did you work with the consultant that they hired to do the RIF?
I
Did you ask him that
I
question?
didn't ask him that
All right.
question.
Oh, when the commissioner sent out the letter in April notifying the district that he was going to put in a board of managers, there hadn't been a RIF declared, had there?
Not yet.
Hadn't been a financial exigency declared, had there?
Not yet.
Their audit wasn't late, had it? Was it?
Yes, it was.
Okay. So the audit was late, but they hadn't declared a financial exigency at that point, right?
They had not.
And that wasn't taken into consideration in the commissioner's letter when he notified them he was installing a board of managers, was it?
The condition of their budget most certainly was a part of that
A financial
consideration.
exigency and declaring a RIF was not taken into consideration by the commissioner when he wrote his letter, was it?
No, but they were
All right.
anticipating.
Ma'am, just answer the question, please.
And let's watch our tone. Let's watch our tone.
Okay. I
Thank you.
apologize, but
Thank
it's a
you.
very limited amount of time.
We will get through this. I'm confident. You're doing a great job. Watch your tone.
Have you ever read Article 5, Section 24 of the Texas Constitution?
I can't say that I have.
Okay. Do you know if it limits the ability of elected officials or directs how elected officials can be removed from office?
I told you I haven't read that section of the Constitution.
So if the Texas Constitution says that you can't remove an elected official in this fashion, you would agree with me that this would be unlawful?
No, I wouldn't. I'm not a lawyer. I don't know the answer to that question.
I thank you, ma'am. That's all I have.
Okay. If I could ask just a couple of follow-up questions. Dr. Don Fisher, when the agency issues investigative reports and finds that laws have been violated, it typically will require that those deficiencies be corrected. Is that correct?
We typically will require a corrective action plan. If that's one of the outcomes that could happen from a special accreditation investigation. There are several outcomes, but that's one of them that could happen.
Okay, so would it be fair to say that any time we see a non-compliance with the laws, that we require that it be corrected?
That's right.
Okay. Does the requiring the correction and putting a timeline on that, does that mean that no violation has occurred until the timeline has run? Is it that, or is it that the violation has occurred and then if it's not corrected, that's a second violation of failure to correct?
Right. The violation has occurred when it's documented in the special accreditation investigation. Then subsequently, if there's a corrective action plan issued and the district fails to comply with it, then we would have a second finding related to that violation of the corrective action plan.
Okay. And so if a student was denied a free and appropriate public education, and then we require them to fix the processes, and we tell them that it must be fixed within a year, does that mean that student that didn't receive their free and appropriate public education, that still happened? That's correct?
It definitely still happened.
Okay. And with regard to the financial exigency, the late audit report, and the proposed RIF, are these consequences from your finding regarding the district's inability to appropriately adopt a budget and stick to it?
We didn't cause the problems by calling them out, if that's the question.
No. Your report found that they were not appropriately budgeting?
Yes.
Okay. And is a consequence of overspending your budget on a continual basis, will that eventually lead a district to declare financial exigency and have to reduce its force?
It certainly can. If a district continues to spend more money than it brings in, it will eventually deplete the savings that it has and find itself in a position where it has to trim the budget.
Okay. All right. That's all I have.
I don't
Okay. Shall we move to concluding comments
Oh, I'm
now?
sorry. I don't have any questions.
Oh, got it. All right. Good, good.
A lot more.
All right, good, yes. I wondered about that. All right. Let's move on. Yeah.
Okay, and then I have no other information to present. And I'll turn it over to the district and note that, that it's 2:40 right now.
So it would be no surprise to Mr. Jones, we've written a brief.
Thank you.
In this brief, and we've spelled out our legal arguments that we're going to go over with you right now. We adopt all of the arguments and evidence that we made in the prior record review that you already have before you. And again, I gave you the transcript to help you so you don't have to listen to the tape. What we'll do is Mr. Rainey is going to argue the constitutional argument, and then I'll argue the rest of the arguments after him.
May I proceed, Mr. Ray?
Absolutely, please.
I think I want to make one point very clear at the beginning, Mr. Berry, is that the Travis County District Court has not conducted a full hearing on this matter. And the Travis County District Court, what they looked at is they looked at the statutory scheme of Chapter 39. There were no constitutional, there was a procedural due process issue there, but there was no arguments by us as to whether or not Chapter 39, specifically 39-102, which they're relying on to appoint the Board of Managers A9, there was no issue in that case taken about whether or not that violates the Constitution. Okay? It has been Mr. Tritico's and Miss Langlois and my honor to represent two school districts when the Commissioner of Education was imposing severe sanctions. The first district was North Forest Independent School District, and this is the second case, Mr. Berry. Both of those districts have a common thread that ran through them, and that is the appointment of the Board of Managers. In North Forest Independent School District, when we got involved in representing North Forest, the board had already been, the commissioner had already appointed the Board of Managers. That Board of Managers had already been there for 2 years, and the duly elected by the voters, the trustees, had resumed their positions. And that's when we got involved in it, Your Honor, Mr. Berry. So we were not around during the tenure of the Board of Managers, and we were not around at their appointment, and we didn't have the opportunity at that point in time to challenge the Board of Managers because, as Ms. Reynolds ruled in the North Forest case, is that should have been done at the time that they were appointed, and she precluded us from challenging not only the board, not only the superintendent, but every decision they made, every decision the commissioner did, the superintendent did, every action the superintendent engaged in. Those were attributed to the board and the district, even though they were appointed by the commissioner and the superintendent was appointed by the commissioner. And so throughout this entire time, one of the things, just to show what a board of managers and an appointed superintendent can do, we were involved, and we weren't involved, but we saw all types of malfeasance, misfeasance, whatever you want to call it. For example, Mr. Berry, the Board of Managers and the new superintendent adopted a 10-month budget. And what they did is they showed 12 months of revenue with the 10-month budget, what made them look very good when it came to their bottom line and their fund balance. They adopted that budget. They were then displaced by the elected board. And so the elected board comes in to run the school district, and they're faced with the situation to where they have 10 months of budget to operate a school for a year.
No money.
They have no money. And so we, at that point in time, we saw how important the decision to appoint a Board of Managers was. We saw how really tragic it could be, Mr. Berry, because the Board of Managers, we don't know what type of experience they have and what their qualifications are, and we don't know who the superintendent's going to be. So during this time, a thing that kept nagging at the three of us is that where does the governor, through his appointment of the Commissioner of Education, have the authority to disenfranchise every voter in a district of their vote to elect these trustees. Where does the commissioner as it stands now can go to each of the 254 counties within the state of Texas and disenfranchise the voters of every independent school district within those districts. The commissioner can do so as his appointee of the government, even though he might have different ideologies, political beliefs, affiliations than those voters who elected the Board of Trustees. And so it kept nagging at us. It said, where on God's green earth does the commissioner get this authority? Where does the governor have the authority to appoint a commissioner that has this authority? Today, we do have a chance to contest that issue, though. We didn't in North Forest, but today we do. And we've searched federal cases, state cases, attorney general opinions, administrative opinions, and the Constitution. And the Constitution is where the authority to remove the Board of Trustee lies and where they grant that authority. The authority that is within the Constitution is the exclusive authority as it relates to disenfranchising the voters as it relates to a county official. The legislator cannot enact legislation in violation of the Constitution. The executive office cannot act in violation of the Constitution. And the judiciary branch is obligated to follow that. This exclusive grant of authority is contained within Article 5, Section 24 of the Texas Constitution here, Mr. Berry. It specifically states that county officers may be removed by the judges of the district courts for incompetency upon the cause thereof being set forth in writing and the finding of its truth by a jury. Nobody's going to take issue with my broad statement that they're trying to remove this board because the Commissioner of Education and those that he has surrounded himself with have determined that this board is incompetent. There's no wrongful act alleged. There's nothing. The Commissioner believes that he can appoint a board of manager and a superintendent that will do a better job. When you look at the Constitution, and the Commissioner is claiming he gets that authority to 39.102A9. That doesn't give him the authority to act in violation of the Constitution, okay? So what we have to do is when we're looking at Article 5, Section 24, we have to look at the elements of Article 5, Section 24. And the first one has to be a county officer, or a county official, excuse me. And so the question then arises, is a trustee of an independent school district a county official? We can look at Hendricks versus State, where that court ruled, when looking at Article 5, Section 24, that trustees of school districts were county officers and that the removal from office on account of incompetency was provided for in Article 5, Section 24. We can look at the Attorney General opinion, DM 114, where the Attorney General said that trustees of school districts have been held to be county officers subject to removal in accordance with the statutes adopted under Article 5, Section 24. Okay? So what they refer to is they refer to the statutes adopted. What the legislature did is adopted Local Government Code Chapter 87. And that provides the way you remove a county official. And even so, those are the statutes adopted to enforce Article 5, Section 24. Am I running out of time?
You're doing fine.
Okay. Also, I refer you to Lamb versus State, Your Honor. I'm sorry, Mr. Berry.
I know.
And
sorry.
It's hard.
It says, school trustees are county officers, and the procedures set forth in Articles 5970 at sequence, which is now recodified as Chapter 87, of the local government code are consequently applicable to suits to remove school trustees. Now, if you pick up the local government code and you look at section 87.012, it says specifically, the district judge may, under this subchapter, remove from office, in subparagraph 14, quote, a member of the board of trustees of an independent school district. The local government code is the legislative implementation of Article 5, Section 24, not 39102, not the Texas Education Code, not the commissioner, and not the governor of this state. The legislature cannot, through 39102, enlarge the powers of the governor or enlarge the powers of his appointee, the commissioner of education. I'm just going to run through a couple of cases, Mr. Berry. Childress County versus Sachet. The court there was specifically looking at Article 5, Section 24, and it states, where the state constitution prescribes the manner of removing a public official, neither the legislature, executive officers, nor the judiciary can act beyond the limitations of the Constitution. What the Constitution does is vest the authority to remove an elected official, and in this case, a trustee of the Beaumont Independent School District. That exclusive jurisdiction rests with the district court in Jefferson County. It does not rest with our great governor, and it does not rest with his appointee. In Downs versus Harney, that court, again, when looking at removal of a county official in this section, said that removal of county officials are also prescribed by the Constitution and by such other statutes as are expressly or by implication authorized in the Constitution. Again, this is Chapter 87. That causes for removal may not be extended by the courts or by statute. They cannot be extended by 39102. Not expressly authorized by the Constitution. And where the Constitution or valid statutes authorized by the Constitution prescribe a method of procedure or such removal, such method is deemed exclusive. It's exclusive of the Texas Education Code, it's exclusive of the executive branch, and it's exclusive of the legislative branch. In Hill versus Lower Colorado River Authority, they state, the powers conferred by the Constitution upon the state officials are generally held to be exclusive, and except in the manner authorized by the Constitution, these powers cannot be enlarged or restricted. Last case on this is State X. Earl Kelly versus Baker, where valid statutes authorized by the Constitution prescribe a method of procedure for removal of county officers. The method is deemed exclusive, and resort may not be had to methods not so prescribed. County officers can only be removed by the judges of district court upon a trial by a jury. That's not happening here. This is far, far, far from a jury trial. This has no rules of evidence, no rules of procedure. It is only the Jefferson County judge upon a finding that can remove these county officials, Mr. Berry. There was a case, the Downs versus Harney case, and it discussed whether or not the Attorney General could remove a county official. And so the court was looking at the purpose of these statutes and what gives the authority to the Attorney General to visit each one of the counties and start removing officials. Where does he get the authority? And the court specifically says he doesn't. But some of the language is very appropriate in this case. And that court said that the right of local self-government in the several counties of the state is one of cherished value, and any attempt under vague or indefinite delegation of constitutional or statutory powers and derogation of that right should be frowned upon and strictly construed by the courts. There is no specific provision nor one necessarily implied from express provision, that the Attorney General, with the great power of his office, may invade. The court specifically said invade, Mr. Berry. Let me start that the Attorney General, with the great power of his office, may invade any one or all of the 254 counties of the state for the purpose of removing county officials duly and legally elected by the sovereign people of the county to such office. This is particularly so in the presence of the power of the electorate of the several counties by vote to oust their officials who have proven recreant to their public trust. Our Constitution and laws have provided rules of conduct for the guidance of county officials and for their removal from office during current terms for infraction of those rules. The Constitution has set up district courts, and the people of that county elect district judges, to whom the power of removal has been delegated after sufficient findings of jurors residing in that county. What the courts have unanimously said is that this is an issue for the voters of the county. The voters elected the district judge. The district judge has a responsibility to do what this commissioner is trying to do. This commissioner, as we saw in North Forest, has no accountability. His accountability was to say, I didn't know this was going on. I didn't know my superintendent was doing that. He's an employee of the district now. He's not with me. I didn't know what the Board of Managers was doing. Nobody was reporting to me on the Board of Managers. The accountability lies in the district court in Jefferson County, because the voters, if the district court does a bad job in appointing the managers, or does a bad job in making a determination whether they can remove these trustees, he or she is subject to that and is accountable to them, and he or she will be at the polls accountable to them. The commissioner, this is the last thing I'm going to get into, the commissioner can garnish no support and cannot try and do an end around by saying, hey, we aren't removing these people. All we're doing is suspending them. That's all we're doing. We'll put them back. We could put them back in place tomorrow. That's not the case, Mr. Barry, because if you look at 87017A of the local government code, it states that the person that has the exclusive authority to suspend a county official is who? The one prescribed in the Constitution, the district court. 87.017A provides that after the issuance of an order requiring citation of the officer, and that's after a petition has been filed, it's been joined by the district attorney in that county, and after the petition is filed and citation is issued to the board member that they're trying to dispose, the district judge may temporarily suspend the officer and may appoint another person to perform the duties of that office. You have no authority. You cannot appoint a board of managers. I hate to say that, Mr. Berry, but I'm not saying it. Article 5, Section 24 is saying it. And you know what? When you sit here and think about it, it's appropriate. The governor, the commissioner is appointed by a governor who's elected by the several counties of this great state.
By the state, yeah.
Yeah. And so how is that elected official appropriate one to determine what's best for Beaumont? He's been invited to Beaumont numerous occasions, Mr. Barrett. Didn't show up every time he was promised he would, but he's invited. I don't know how familiar he is with it, but he's not accountable. The decision as to replace, I tried to think of examples of this, but it's like the commissioner coming to me and saying, Ron, I'm sorry, you can't homeschool your kids because we don't think you're doing an appropriate job. That's not his decision. it's like the commissioner saying, I'm going to disband all charter schools because we don't think that they're doing an appropriate job. It's like the commissioner coming to me and saying, you send your kid to a private school, we're not going to recognize that school. And so what you have to do is you have to send your kid to a public school. I've tried to think of examples, and to me, they just flow and flow and flow. But an appointee of an executive branch does not have the authority to do what he's attempting to do. And I'm going to turn the rest over to Mr. Trigg.
To paraphrase my good friend Joe Pesci, we're going to need that 15 minutes. We have two more sections in the brief. Section 3, I'm not going to argue. It's already fully covered in the first record review. We're not waiving anything, but I'm not going to belabor the point without waiving it. Section 2 of the brief discusses the appointment of the Board of Managers and the naming of the Board of Managers and the naming of the superintendent. Let me back up. The day Mr. Rainey and I were hired to represent the Beaumont Independent School District, we sent a fairly extensive request for records to the agency. They did not turn those over within the 10 days prescribed by the Texas Open Records Act, or whatever we happen to be calling it these days. Whatever. I wish they would just pick a name and stick with it. We actually got those records yesterday. Some of them. We still are awaiting a good portion of those records that they claim we can't have for 2 weeks. We filed a motion for continuance last night, and you denied that this morning. I did want to take issue with one point in your ruling. You said that it has to be done within 30 days, and I disagree that that's what the law says. I think the law says clearly that you can grant a continuance if you want to. But you chose to deny it, and I will live with that. But the point is yesterday we received thousands of pages of documents. We stayed up a good portion of the night, last night, reviewing those documents to find if there was evidence in there, and we found some, and I'm about to show it to you. And the reason I bring this up is because Section 39102A9 discusses the appointment of a Board of Managers, and the appointment of, and the next section is the appointment of a superintendent when a Board of Managers is put in place. We have asked on numerous occasions for the names of those persons that the commissioner was going to name as the Board of Managers, members of the Board of Managers and the superintendent. We have been repeatedly told that decision has not been made. When we reviewed the documents that we got last night, as best we could in the time we had, we found some documents that that show us that the decision regarding the Board of Managers was begun before the letter was sent to the Beaumont Independent School District notifying them that a Board of Managers is going to be put in place. And hang on just a minute. And I'll give you what I've marked as Beaumont ISD Exhibits 177, 178, and 179. I couldn't submit these to you by the deadline because I didn't get them till yesterday. In Exhibit 177, you see a email from a gentleman named Jim Rich to Paula Myers, CC'd a bunch of people, discussing the suggestions for the Beaumont ISD. And you see that Ms. Myers sent it to Commissioner Williams, who sent it to the COE, whoever that is. Commissioner Williams, pursuant to our conversation, I'm providing you with names of possible managers for you to appoint from the point of view of the business community. This is April 17th, 2014, and it's got a list of names of individuals that they're suggesting for the Board of Managers, which means that the Commissioner had a discussion with Mr. Rich. I'm going to suggest sometime before April 17th of 2014. Exhibit 178 is an email from Jesus, I want to apologize to him, Babrego. I don't know what I just did to his name. to Paula Myers, who then sent it to the commissioner. This email was on April the 10th of 2014 from Jesus to Paula Myers. This is 4 days before the commissioner signed the notice letter to the Beaumont Independent School District informing them that he had made the decision to install a board of managers. In this letter, Mr. Abrego says to Paula, can you please provide the commissioner with these names? During our conversation yesterday, he asked me to send him some names for a possible board of managers. Exhibit 179 is an email from the commissioner to Ron Rao and the COE, again, whoever that is. This is on April 15th, 2014. Please prepare to give me a recommendation. This is regarding interim superintendents, and it's got the names of 3 people and then anyone else I should consider. Now, why is this important? Because we've been told repeatedly this decision has not been made. What we found, what has happened in the past, is when we began to object to the actions of the Board of Managers, it was ruled by this agency that we waived it. And I will address you to the attachment to the brief I just gave you. If you'll look at page 23 of the attachment.
It's an opinion.
The opinion. I'm talking about the opinion from
Yep.
Joan Howard Allen sent it out. I'm going to read it to you if I can find the page myself. 23. I'm almost there. Page 23 at the top. The selection of 2 members from the community to serve on the Board of Managers was not required by law and contributed to the lack of financial and educational expertise of the district. That's the hearing officer, Ms. Lizette Reynolds, paraphrasing what our argument was. Here's her ruling. This challenge is untimely. If the district believed that the selection of the members of the Board of Managers violated statute or rule, it could have challenged the action through an appeal pursuant to 7.057, which she's in error about, but the timeline for the filing of such an appeal is 30 calendar days after the decision, order, or ruling complained of its first communicated to the complaining party. Now, what's the problem with that? I'm sure you can see the problem with that. Once you rule that they're out of office, if it holds up, there won't be anybody there to complain. I am quite certain that if I ask the Board of Managers for authority to complain about their appointment, they're going to say no. And so there won't be anybody left to appeal to the agency regarding the appointment of the managers or the superintendent if they are not qualified to do the job that the commissioner is asking them to do. And so what they have done by refusing to give us the names so we can lodge our objections now is, in effect, put the district in a position where they are not allowed to complain about the commissioner's decision, and that is an error. That holds true for the superintendent as well. And so the commissioner is placing the district in a position of waiving any argument they have to his selection of the Board of Managers by refusing to give us the names when we know he's been working on it since April. They didn't even give us the top 10. Well, we got it last night. Well, these aren't the top 10. These are just suggestions from the public that the commissioner was talking to members of the public. In her ruling, Ms. Reynolds suggests that the proper mechanism would be for the district to file a complaint under Section 7057. That doesn't apply to the school board. It applies to members of the public. And the school board's objection would come through an objection here at the agency level. And the agency has prevented the district from lodging any objections under that. And it's for that reason, as well as what, and we'll have some closing statement in a minute, but for those reasons, I ask you to deny this. I do want to address just a few things from the testimony earlier. The Jefferson County District Attorney did not direct the district not to vote on a RIF. The board, in a public meeting, voted, and they chose to vote it down. And as was stated by, I don't remember who said, but stated by one of the board members, at one of the most contentious board meetings I've ever attended in my life, it was stated by one of the board members, "You have been telling us not to do this for months. We followed your decision. All right, we did what you asked us to do," and left it to the Board of Managers, if they go into place, to put that in. I believe what Ms. Dawn Fisher is confused about is the district attorney sent a letter about regarding the previous meeting about something that had not been properly posted, and the board did not vote on that. Had nothing to do with the RIF, had nothing to do with the declaration of financial exigency. That was a proper board vote that failed. You have several options for the Beaumont Independent School District. The Board of Managers, I think we can all agree, is the most drastic measure that you have in your quiver. A conservator, a management team, two conservators, can take care of all of the issues that the commissioner has. What we know now is that this district has been given notice just a few months ago about the majority of the complaints that the commissioner now has, and they have not been given any time to fix it. In evidence before you is, as I said earlier, the Plano Independent School District issue, where they had a theft far greater than this, that a board member was participating in. The board member was indicted. The commissioner took no action against them regarding the financial improprieties at the district. The commissioner put in an academic conservator. The issues that the commissioner raises need to be fixed. They need to be addressed. This board can address that. The better way to handle this is to follow the law and put in two conservators, if you want, and allow them the time to remedy it, the time that was suggested by the agency and by the Legislative Budget Board. That's the appropriate remedy. And quite frankly, the commissioner would have far more authority and far more oversight over the district with two conservators than he would over a board of managers, because as is stated in the ruling that you have by North Forest, when the agency ruled on the North Forest matter, is that once the board of managers goes in, the agency doesn't have any authority. As a matter of fact, in North Forest, they took the conservators out when they put the board of managers in. Nobody was there to oversee what was happening except the superintendent that was sent in by the commissioner, who was later fired. And so if you want to maintain control, if the agency wants to maintain control, then put in the conservators and follow the law. That's our presentation. I'll have a brief close.
Let me, in closing, address a few of the issues that were brought up. And first, in terms of the constitutional issue that was raised, I think it may be a little premature to be talking about constitutional issues. This is a system of separation of powers. There's three branches. There's the executive, the judiciary, and the legislative branch. Each has specific duties. The legislature passes laws. The administrative branch, the executive branch, enforces laws that are passed, and the judiciary determines whether the laws that were passed are constitutional and adjudicate disputes. Administrative agencies do not have the authority to declare statutes unconstitutional. That authority was taken by the judicial branch in Marbury versus Madison, which every lawyer likes to cite to. So that established the doctrine of judicial review, where a statute can be struck down for being unconstitutional. It'd be an overreach for this agency to write back to the legislature to tell them, we think that your law that you passed was unconstitutional. That's the province of the judicial branch. Now, the Board of Managers has this has been around for quite a while, and we've put in multiple boards in the past. They have been challenged, and the constitutionality of this appointment has stood up. And there are several cases that are not cited in the brief that will tell you about that. In fact, this provision that they cite to is about removing public officials for drunkenness and things like that, that you would want to have a jury trial about. But there are also numerous statutes that remove county officials through redistricting and through something like a board of managers that has withstood constitutional scrutiny. And that is, and there are multiple ways to remove county officials for things other than drunkenness that are in the statutes and that have been upheld. So that's kind of how I would address those constitutional issues. In terms of, they provided some emails here and stated that the commissioner had determined the board of managers, but wouldn't tell them well before today. But those emails that were shown to you, these are recommendations. Lots of people send emails to the commissioner and make recommendations. We'd like this person on the board. He gets flooded with these things, and that does not mean that he has either made a decision or that decision is appropriate to be announced at this point in time. And it is true that the district's legal authority is to defend its operations. Say this district doesn't deserve a board of managers, and that's certainly what they're qualified, what they're authorized to do. The selection of the board of managers is within the discretion of the commissioner and is not subject to a separate legal review. And so the commissioner sets that board. That's the commissioner's discretion. That's what discretion is. And he is ultimately responsible for the acts that he takes. But that does not mean there is a legal process that is available to the district. That legal process would have to be authorized by the legislature, and there is no authorization that I see at this point. And then lastly about, and that deals with their who's going to have the authority to complain about the board of managers. And I would agree that the citation in that North Forest case saying that there's a 7057 appeal, that statute has been subject to a lot of opinions recently. But Judge Jalinovsky looked at that in their temporary injunction hearing, and he said that does not apply to the actions of the commissioner, and so to that extent, there is no legal authority for the board to challenge the actual naming of those individual boards under state law, and I would agree to that. But if the legislature doesn't give you the authority to do that challenge, then that authority doesn't exist. So for these reasons, I think we have demonstrated in the record the actions that have occurred at the Beaumont Independent School District really require you to appoint a board of managers so that we can protect both the interest of the students and the public interest, and that this board has demonstrated that it is either unwilling or unable to correct the problems on its own. Thank you.
If you don't mind, I'm going to stand. I know this is informal, but I
That's
can't make
fine.
an argument without standing.
Sure,
It's
absolutely.
It's just something I have to do. I find it so odd that government always mitigates the Constitution. We are a country in a state of laws, and one of the things that we believe in this country is that our Constitution works. It only works if everybody follows it. You know, in several years ago, when the election of Bush versus Gore went on, there was a challenge. I think you may recall a challenge that went to the U.S. Supreme Court. The U.S. Supreme Court ruled, and basically they picked the President of the United States. And in most countries in the world, that's not fair. In a lot of countries in the world, there would have been a revolution over that, over the way that our Supreme Court handled. There would have been a revolution. But what we did was, in the United States, was we said, I don't agree with that, but the court ruled, and we're going to move on, because that's what the Constitution says. And today, this agency says, well, that's just the Constitution. It's premature to talk about that. It is never premature for us to follow the law. It's never premature for any governmental agency to follow the Constitution. And here's what it says, Mr. Berry. Now, my good friend Chris just said that it deals with drunkenness. He only gave you part of it. I'll read you the whole thing. Article 5, Section 24 of the Texas Constitution. County judges, county attorneys, clerks of the district and county courts, justices of the peace, constables, and other county officers may be removed by the judges of the district courts for incompetency, official misconduct, habitual drunkenness, which counsel pointed out, or other causes defined by law, upon the cause therefore being set forth in writing and the finding of its truth by a jury. The very issues, the very reason that the commissioner says we need a board of managers in Beaumont is the very reason that the Texas Constitution says that's how you remove a school board trustee. And so if the commissioner signs an order removing them, he is doing it in direct violation of Article 5, Section 24 of the Texas Constitution. It is not premature today to ask our Commissioner of Education to follow the Texas Constitution. It's no more premature today to ask him to follow it than it is when we ask a police officer every day to follow the Constitution when he arrests someone and they call him a bad name. We don't want that officer to beat the living crud out of him because he got mad, because that would be a violation of that person's rights. Well, this is a violation of the rights. This is a violation of the right of every voter of Jefferson County, the Beaumont Independent School District. If the commissioner does this action today, he's violating the Texas Constitution. That's more important. That's more important than this agency asserting what it believes to be a right under the Texas Education Code. Because the legislature cannot pass a law that circumvents a direct command of the Texas Constitution. If they do that, they have to amend the Texas Constitution first, and that has not occurred. Those emails that I gave you, I did not put in the multitude of emails from citizens that said, here's my best friend would be good at this. I didn't give you those. I gave you the emails where the commissioner himself had reached out to citizens and said, give me some names. That's what these emails say. And so I find it very odd that there's not one name that can be given to us to evaluate so this board could make a proper objection today as to the qualifications, especially when we've made these objections before. These three lawyers have made these objections before, and the ruling from this agency was, you didn't make it timely. You're preventing me, not you. They're preventing me from making a timely objection to anyone on this board of managers, and if they're incompetent, the issue gets worse. Mr. Berry, there's one simple solution here. Follow the law. I ask you today to follow the Texas Constitution. I ask you today to follow the law and say the commissioner is overstepping his authority. I ask you today, this is hard to do because it's your boss, but I ask you today to order that the commissioner stop what he's doing. And I ask you, put in 2 conservators, put in a management team over there, put those 2 conservators in, keep control over what's happening in that district, and let's together work to fix the problems. That gives the agency the oversight authority that it wants, that it needs, that it's going to give up with a board of managers. And it lets us work together to fix these problems. That's the right thing to do. Follow the law, sir. Thank you.
All right, this brings the record review to its conclusion, and the record is now closed. I want to thank everyone for being here today, and I will review the material presented. I think you wanted to make sure I didn't have a weekend for what you gave me, but I will enjoy going through all of it, and I will issue a decision as soon as possible. Thank you.
Thank you.
Mr. Berry.
How's that?
Thank you, Mr. Berry. It's a pleasure.
Thank you. I'm sorry I lost my temper earlier.
Push.
Yes, you have.
Make it go off.
And I'll be back this summer.
Oh. See, I can push it and oh, look.
It's off.
It's a pause. Okay.
My last quiver was.
Oh, no, I'm just trying to fix it. There's a little button.